Did you know that one way to beat a DWI is to challenge whether the officer had the right to get you out of the car and test you for DWI by giving you the field sobriety tests and the handheld breath test, usually called a PBT? This is one of the videos that I'm going to use in a series of common challenges to DWIs, and today I'm talking about expansion of the traffic stop. Here's what that means. That under the law, an officer, if they want to test you for DWI, has to have more proof than just that you've been breaking a traffic law, or perhaps that you've even admitted to drinking prior to the time that they ask you to get out of the car. To expand the scope of the traffic stop and test you for DWI, the officer has to actually have what's called a reasonable articulable suspicion that you're actually over the .08 limit or that you're impaired. So I'm constantly reminding judges and prosecutors about this, because a lot of times a judge or prosecutor will say, well, the officer noticed an odor of alcohol, or the person admitted that they were drinking before driving. Well, it's not illegal to do that. It's not illegal to drink and drive. It's only illegal to be over the limit or impaired. And if an officer just forms a belief or even gets an admission that you've been drinking, that alone is not enough to get you out of the car and test you for DWI. What happens if that's all they had and they got you tested for DWI? Well, you or your lawyer can bring a motion to combat that and motion to suppress that evidence based upon an illegal expansion of the traffic stop. We do that in many cases, and an order I just got back in the mail today from a judge indicates that strategy worked. We were able to get this person's revocation of their driving privileges rescinded, which means the DWI taken off of their record and their driving rights restored to them. And we've done that in criminal cases to beat the DWI as well, because the law says that if an officer unlawfully gets you out of the car because it turns out they didn't have enough proof to get you out of the car, that no matter what happened after that, it can't be used against you in your case. In fact, in this case, my client blew a .17, well over, more than double over the legal limit, yet we were able to beat her case. And that is because an officer will usually, the first thing they're going to do is find out why they can pull you over. Let's presume for a minute that they pulled you over for a legal reason. In this case, it was an illegal window tint, and sure enough, her window tint was way beyond what was allowed under Minnesota law. But it could be for speeding, it could be for going too slow, it could be because your tabs are expired, it could be because you have a tail light out, or whatever they pulled you over for. In this case, it was good because it was just a equipment violation. It wasn't something like she was weaving all over the road, crashing into mailboxes and things like that would give an officer a belief that someone's pretty hammered if they're driving. So this was just a situation where it was a simple traffic stop based on equipment violation. In other words, that doesn't give an officer a reason to believe that my client was impaired or over the limit. When he approached the vehicle, he said he noticed that her eyes were bloodshot and watery and glazed over, and that her pupils were dilated. And based upon that, and then an odor in the vehicle of cigarettes, he determined that he wanted to get her out and investigate more. He thought that the cigarettes were a masking odor for alcohol. So we challenged it based on that and said the officer, number one, has to look at what's called the totality of the circumstances. And that means not everything that's just bad in the case against her, but everything that's good. There are some cases in Minnesota that say that an officer can pull you over, can get you out of the car if they even notice one indicia of intoxication, and that's the odor of alcohol or slurred speech or bloodshot watery eyes or notice a beer can in the car, whatever. But I think those cases are all different, and even in those cases there was more than one factor in each one of those cases that gave the officer a reason to get the person out of the car. So here, that's what the officer testified about, and we challenged it and said, look, the driving conduct, Your Honor, it wasn't bad, so that alone didn't give him a reason to suspect she was impaired, and then he's just speculating about whether there's an odor of alcohol at that point in time. Yeah, her eyes looked weird, but we don't know what what about them could be weird. And so he illegally ordered her out of the car to investigate her for DWI and illegally expanded the scope of the traffic stop. We pointed out such things as she wasn't weaving, she wasn't swerving, she didn't cross over the fog line or the skip line, she stayed within her lane perfectly, she was going the correct speed. When the officer put on his cherries to pull her over, she pulled over when she was told to and in the right manner. Sometimes we get clients who will pull up right onto a curb, or they'll pull over crooked, or they'll drive for a half a mile when the cop's behind them trying to pull them over because they're intoxicated to the point they don't realize that a cop is trying to pull them over. Those are some bad facts. In this case, though, there were some pretty good facts, and they can be used to other people's advantages in other cases as well. So it's illegal for an officer to expand the scope of the traffic stop to do anything more than the original purpose of the stop was. So what I'm talking about here is, in this situation, for example, window tint, or let's use speeding. Under that, an officer can only keep you around long enough to write you a ticket for that, and they can't get you out of the car, again, unless they believe that you're actually impaired or over the limit. And if we can show that, look, just the odor of alcohol isn't enough, or just so what? So you smell of alcohol and you've admitted that you had a drink an hour ago. That's not enough for an officer to believe that you're actually impaired or over the limit, unless they see, in my opinion, some other things like slurred speech, your inability to follow directions, lack of motor coordination, really bad driving like weaving all over the road or something. The more they have of that, the better chance they have of getting you out of the vehicle. But otherwise, that's a challenge that should be made, and it should be argued that the officer didn't have what's called enough of indicia of intoxication, or signs that the driver was actually intoxicated or over the legal limit, looking at the totality of the circumstances, meaning not just what's bad in the case, but what's good about it. Good driving conduct, the ability to pull over, no slurred speech, being able to follow the officer's directions and comprehend what he or she is saying to them, and so forth. And we have to look at those totality of the circumstances and then determine whether or not the officer had enough of a basis to believe that you're over the limit or impaired. If not, the officer can only keep you around long enough to write you a ticket for whatever, and they can't get you out of the car to do that. And the minute they try to get you out of the car and then they notice something else, let's say they only notice what I talked about when they had her in the car, and then they get her out, and now they notice the odor of alcohol, or now they notice that her balance is bad or something, that's too late. Because once they've asked the person out of the car, that's all they can think about is what they saw before that. The law has to ignore anything that the officer learns after they get them out of the car if the expansion of the stop is improper and the driver's constitutional rights were violated. So that's the piece on expansion of the traffic stop. You can check out other videos that'll be coming up for other challenges to DWI. And if you want more information, my name's Ryan Pasiga. My website is www.arrestedminnesota.com. And our phone number is 612-339-5844.